Hello, everybody, and welcome to the Ask JP podcast, where we tackle head-on the issues of the day. Today is yet another episode in our ongoing criminal justice reform series. Today, we have the fortune, the ability to speak to Marcus DeLarge as a candidate for criminal district court judge. Marcus is a graduate of St. Aug High School and Xavier University of Louisiana, earning a bachelor's of arts degree in political science and a minor in French. Marcus is a graduate cum laude of Southern University Law Center in Baton Rouge. He was also a vital part of the criminal law clinic, where he worked on behalf of the most marginalized and under-resourced clients in the Baton Rouge area and gained important trial experience. Marcus began his career in criminal law as the Orleans Parish Assistant District Attorney. Following his tenure in the District Attorney's office, Marcus returned to St. Aug High School, serving as Director of Athletics and Activities while building his own criminal defense firm as DeLarge Law and Associates. Go right ahead, Marcus. Take it away.
And good morning, everyone. My name is Marcus DeLarge, and as Mr. Morrell said, I am a candidate for Judge Criminal District Court Section K, and obviously I ask for your consideration for your vote on November 3rd, and actually early voting actually starts this Friday. So, if you want to get to the polls early, I certainly encourage you to do just that. We are expecting, a record turnout this year. So, definitely get out and vote, and definitely consider me as your choice for Section K.
I appreciate that. So let's get right into it. So, real basic question: why do you want to be a criminal court judge?
So, that's people ask that. They ask me that question, and I give the same answer. Growing up, I knew I wanted to be a lawyer. I knew I wanted to be a criminal defense lawyer since I was maybe 12. So I've been taking steps for me to do just that. As I got into criminal law, I kind of learned the inner workings of the system, and I figured that I can help more people from the bench than I can from my criminal defense practice. So when you ask me why I want to be the judge, because I want to help. I want to help the young men and women that come before the judge. I want to help our community. I want to serve. You read some of my bio, and you'll see that, I've been serving this community since I was a young professional. I started teaching right out of Xavier when I was 21. It's that service component. It's that desire to help, that want and that need to feel that our community can do better. And I feel that I can certainly be that vessel for change from the bench.
Okay. As far as judicial philosophy, what can a person, whether they be a criminal defendant, whether they be a prosecutor, defendant, the public, what can they expect in Judge DeLarge's courtroom?
So I think what they can expect is, first of all, is that I'm going to be prompt. Even this meeting today, I logged in a few minutes early because I don't want to be late.
Right.
I never want to be late to any event, any party, and anything. And I certainly won't be late to court. So first thing they can expect is that I'm going to be prompt. I'll be prepared. If it's something that's set for a ruling that day, the ruling is going to be levied down that day. It's going to be handed down that day because I've done my homework. I've done my research. I have my response ready. I'm prepared. And I think those two are both important so that everyone knows that when you come into Section K with Judge DeLarge, you need to be on time and you need to be prepared. And that's how cases can begin to move through the system. Now, I'm not trying to rush the case because another thing that you'll find is that I'm fair. I'm going to be fair to both sides. That's both the defense and the state. I have the unique ability to do that in this particular race because I've sat on both aisles. You told the people that I started my career as a prosecutor, and
Right.
Now I'm a defense attorney. So I understand how the prosecutors view cases, and I obviously understand how defense attorneys view cases. And that experience, or those experiences, allow me to be fair and impartial. At the end of the day, the judge is the referee, and I intend to make sure that everyone stays inside the rules and colors inside of the lines.
Okay. What are your current thoughts on the criminal justice system at Tulane and Broad? And by that, I mean, you've been a practitioner both as a prosecutor and as a defense lawyer. what is your impression of the way Tulane and Broad is run currently as far as judges are concerned? What are your frustrations? What do you see as things that you would want to change as a judge?
So the first thing that we have to change is, and this is a systemic problem. It's not just Orleans Parish Court. Is there's some implicit racism that goes on from this. This is from the top down. It's not necessarily. I'm not implying any judges racist, but I am saying that our system is. It unfairly targets people of color. So as a judge, there are ways that you can curb that behavior. And I definitely intend to do just that. There's some other issues that I see at Tulane and Broad as I go to other parishes around the state and even other states. We have a lack of technology problem. Our technology inside of the courtroom is, I mean, we have some, but it's certainly not to the standard that I would expect and one that I would implement in my court. I know judges get a budget, and I can tell you I'm gonna spend some of mine on technology because I think with the use of technology, we can get cases through the system faster, especially on a day-to-day basis. We can eliminate the need for this paper, so we can reduce our carbon footprint in the world. There's some other things that I just think that we can do to keep moving our system forward. The system obviously has some issues, and those issues certainly will be addressed, and I'm not afraid to tackle them head on.
Okay. Let me get into some more specific issues that affect criminal district court that a judge actually has some input on. What is your position on the cash bail system? And if you don't agree with it, how would you change it?
So first of all, so this is a hot topic question. One of those buzz questions that a lot of forums ask about cash bail. And as a former senator, the cash bail system it comes from our legislative body. As a judge, I can't just change it and throw it away. What I can do is work within the confines of it that I have. So for your nonviolent offenders, your low-level offenders, you can issue RORs. Those people are not a danger to the community, so they can be released on their own recognizance, so they don't have to pay money that they probably don't have to bond out. And you're also not, just flooding jails with these low-risk offenders. Now, with regards to the rest of it, I believe that the purpose of bond, per the code, is to ensure a person's presence at court. So we have to keep that in mind, that's the purpose of bond. Now, there are a number of factors that a judge can and should consider. And what I intend to do is have a little bench card. And there's going to be some questions that I ask each and every defendant when I'm setting a bond that enables me to delve into their financial history, delve into their criminal history, so that I can set an appropriate bond. We just don't want people sitting in jail just because they can't afford to get out. Like, that's not fair to them. It's not fair to their loved ones. But, on the flip side of that, their presence has to be secured by something. Right. Whether it's cash or some other collateral, it has to be secured by something outside, obviously, those low-level offenders that I spoke of, that I have no issue issuing RORs for those individuals.
Well, I mean, also, just generally speaking, judges also have a lot of leeway in doing alternative means like electronic monitoring or other things for those people who, if they don't meet the financial criteria for able to get a bond, you also have drug tests and other things you can do to secure someone to return or to stay on the straight and narrow up to court coming up the next time. So, I mean, having the flexibility to look at that and not just be restricted to cash simply is certainly something that every judge should look at.
And I agree. And, we have pre-trial services that we actually use at Tulane and Broad. Now, and I certainly would use it and try to expand upon it. We want as many people to get involved in those type programs in lieu of paying money to get out. But, unfortunately, no judge can just throw the cash bail system out, because that does come from our legislative body. And as a judge, we have to follow the law. And I intend to do just that.
Okay, what is your position on mandatory minimums? Obviously, as both a prosecutor and defense attorney, you've seen mandatory minimums quite a bit, multi bills, triple bills, the whole deal. And as a judge, as a first off, like as a practitioner, you have some from framework as far as what you think of mandatory minimums. But as a judge, what is your position on mandatory minimums and how they're applied, and how do you intend to interact with prosecutors who seek mandatory minimums?
So obviously the our code, it codifies, these some of them have these mandatory minimums as you're suggesting. And look, I'm not a big fan of it, to be honest with you. I would rather that person go through that process and then let the judge decide, because that judge has the facts at his or her disposal, has the person's criminal history. And normally when you go through this process, the judge, inevitably gets to know the person. And I think that judge should be able to have a wide range of discretion when sentencing an individual. Right now, the judge, he has discretion, but it's confined to the parameters that exist in the code for that particular crime. So I would like to see that judicial discretion expanded, because I think the judge has a better working knowledge of that individual. He probably knows what type of person that individual is a little more intimately than the legislators, no offense, who actually wrote
None taken, none
who,
taken
who,
on that one, right?
who actually wrote the laws. So I think, when you take all that into consideration, I would like to have more discretion. Obviously, in some cases, you don't. It kind of is what it is. But and I'm also not a fan of this multi-bill or the eventual offender statute, because I've seen it literally be used to entice people to basically give up their rights, entice people to plead guilty because they don't want to face going to trial, because they know if they lose, they're gonna be multi-billed, and now they're doing a considerable more amount of time, and a lot of time that time is what we call flat time,
Right.
meaning it's day for day, as opposed to if you're offered a no bill and something where you can get that good time, and get out early. So they're trying to avoid that, but I don't like that. Is they literally dangling over their head, and I don't think that's fair. I don't think that judges should use what's called a trial tax,
Right.
because a person wants to exercise their right. Like, that's their right. You want to go to trial? That's fine. I'll make sure you get a fair trial, and I'm not a fan of a trial tax. I'll listen to the facts. If it comes back not guilty, you're gonna be a free man or
You're,
woman.
I love you use that term because, like, as practitioners, like, no other judges talked about that, but it's like it's the unspoken rule when you're dealing with a DA and you're a defense lawyer. They go, if you make me go to trial, the judge doesn't want to go to trial. This is gonna be on you. That was that trial tax, and I mean, people don't talk about it, but it's a thing. I mean, you have judges that they're so obsessed with the Metropolitan Crime Report's ranking of how they move cases, making them have a multi-day trial makes them angry. And to hear you as a potential judge say, if you want to exercise your rights, you have the right to exercise your right. That's refreshing. I mean, because at the end of the day, like, people should be able to say, I'm innocent. I want to go to trial. I'm not going to be pressured into a plea and go to trial. I mean, that's seems basic, but I hadn't even thought about that because no one else talked about it, but it is like the thing. Like, every practitioner knows there's that trial tax. If you want to go, we can go, but this judge is going to slam you for it. And it's like, it's nice hearing someone say, nah, there's no trial tax. You want to go to trial? It's the Constitution. You can go to trial.
And I agree. And you shouldn't penalize a person for exercising a constitutional right. I actually think that's kind of crazy, but but that's how it's gonna be. And when I say fairness, these are the type of things that I'm talking about. I'm not talking about just fairness, with regards to the rules of evidence, or what objections get sustained and what get overruled. I'm talking about fairness, like, you're gonna have a fair shot, and you don't have to worry about the judge in this case feeling any type of way, or any preconceived notions or prior opinion or bias about the individual, because of the facts, and or because they actually exercise their right to go to trial.
Okay. Well, next thing, death penalty. So I'm going to bifurcate this because judges are in a very interesting spot. what is your personal opinion of the death penalty? Because that's separate from, and then what, as a judge, do you think your position on the death penalty, how will you deal with it? Because I mean, obviously people have their own personal opinion. As a judge, you're kind of restricted in how you exercise that. So give me both. Like first, what's your personal
So,
opinion on death penalty, and what will you do as a judge with death penalty cases?
so my personal opinion on the death penalty is, I think that every life has value. And even a person who, is convicted of the most heinous crimes, that life still has value. So I'm against the death penalty. Personally, in my personal life, and in my heart of heart, that's I don't want to condemn someone to death. Okay. Now we know that the law is the law is the law, and as a judge, I have to follow the law. So if a jury comes back, in a capital case, and they say, they agree that the person, is gonna the sentence, is gonna be death, then I mean, I have to follow the law, and I don't have a problem doing it. But it's not gonna be my best day on the bench. It won't be my favorite thing to do from the bench. But again, I will follow the law. And as a judge, I think that's what all judges should do. But I'm against the death penalty. I think that that person. I'm not saying that you know that they should go home or anything like that. But what I am saying is that individual, he or she can be rehabilitated and can serve as a mentor to maybe some younger people who are coming through the system and say, hey, look, I made some bad mistakes, and this is where I am because of it. You don't have to do that.
Okay. That leads into the next question, judicial activism. And I'm going to kind of give you a little background on the question just so you can understand what I'm asking. So there's kind of two schools of thought on judicial activism. There are some people who say judges should follow the black and white law. It should be strict interpretation of all law. Apply the law the way it is. Don't have any personal opinions. Don't have any personal experience. Ignore everything to the contrary. If case law says X, if this is X, this is just the way it is. Then on the other side of the spectrum, people saying, if you see something, say something. If this law is jacked up, if it's wrong, if it's been interpreted wrong, you're a judge, elected you to do your job. You need to do something about it. Where do you fall on that spectrum? Like, do you see yourself? Do you believe that judges should be activists? And in some cases, if they are going to be activists, how activist can judges be, or will you be?
So let me begin the answer by saying a judge should follow the law, and
Right.
the law is the law. But if there's a law that's unjust, then a judge has to say something. If judges never said anything, you and I, we may not be in the positions that we're in today. Let me just say it like that.
You're
Okay.
100%
So,
correct. That's a
so
good way of
somebody
looking at it.
somebody has to step up and say, hey, this is not right. As judges in criminal district court, as state level judges, we are elected. I mean, the people go out and vote for us. And I believe that we are responsible to those people. So to ignore unjust law, or a law that is clearly shouldn't be on the books, you're not doing your job by being responsible to the people. So to ask you to answer the question, I think you can see where I'm going with this,
Right.
that I'm going to be an active judge, or however how you want to call it, because I'm going to call out bad laws. And I
Okay.
don't have a problem doing that. If you want to call me to the Senate floor, to the House floor, or one of these committees where I have to testify to why I think that law is bad, I don't have a problem doing that, because at the end of the day, what I want is to serve the community and be the very best judge. And I tell people this all the time. I don't want to be a judge. I want to be the best judge that I can possibly be. And that means that I'm one that is responsible to the citizens that elected me. And I intend to do just that. I've been in this community. I've been fighting in this community. I've been fighting for our young people. And I'm going to continue to do that from the bench. Make no mistake about that.
Okay. Uh, do you consider yourself a reform candidate? Let me kind of give some background on that, because let me be clear, everyone's a reform candidate apparently. But um, identify some of the things you believe are reform and why you think that you are the best person to implement them. If that's a better,
So,
that's probably a better way of looking at it.
so when I think of reform candidates, like you said, everybody's a reform candidate because they want to change something
Right.
about the system. Nobody is just walking in and just going to keep everything as it is. And look, one of the things that I want to bring to this court is I want people's perception of court to be a little different. All right. Right now, everybody that comes to court, not everyone, but most people, it's a negative connotation or a negative experience. And when you come in Section K, I want that experience to be as positive as it possibly can. Win, lose, or draw, you're going to get a fair shake. And I think that's really important. I've seen judges that, treat defendants almost like animals. They talk down to them, they're condescending, and I'm not going to do that. Those are human beings. They're presumed to be innocent, and we're going to treat them as just as they are, as a human being. That's the first thing that we're going to do. And look, one of the things that I want to bring to the court is, a robust mentoring program. I haven't seen it happen. I know they have the reentry court and they have a mentoring program within that reentry court, but mine is for people who are not incarcerated. I went to St. Aug, and one of the things that St. Aug does really well is they surround young Black boys with positive Black men. Every day, every classroom, every sporting event, you're surrounded with positive Black men. And I want to bring that same philosophy to the bench. So when you're talking about reform, and this is something that we can do, is we can infuse these young people that come before a judge with positivity. And somebody asked me the other day, well, when the case is over, does the mentoring program over? And I said, no, that's the beauty of it. That is your mentor. That's your mentor for life. They're going to stay with you. And I intend to keep track of it and check in on you to make sure that you're doing okay, because it matters. We can make a change, but we have to put in the work if that's what we want to do. And if we can make that change in that one person's lives, that begins to snowball. And now we can make a change in 2 and 3. And now you can see a change within our community. And that's what the ultimate goal here is to change the community, to put us where we need to be. Because right now we're not there. We know that, unfortunately, New Orleans is a city that is riddled with violence. And we want to change that. You want to change that, it starts with one person, and then it snowballs. And so that's the goal that I have for myself for Section K.
That's a very robust, I think it's a good answer. Let me ask you another kind of off the wall question. What's it like campaigning with COVID?
So like, this is my first time in a campaign, so I don't have anything to compare it to, but I know I've experienced campaigns, right? I've seen people knock on my door and talk. We're not doing that sort of thing, so we're doing this. Everything is kind of virtual. So I think social media is really important. That's not to say I'm not getting out in the community, because I am. I'm trying to be socially distanced and maintain that 6 feet. You see push cards kind of converted to door hangers and that sort of thing. You see virtual fundraisers and virtual events. So it's interesting. But look, I'm a younger candidate, so I guess I'm kind of tech savvy. So, it's still fun to me.
Right.
I'm still enjoying it. I didn't know, you decide to run for office for the very first time. You really don't know, how the campaign is going to shake out. But what I can tell you is I'm enjoying this process. I do enjoy putting my signs up. I enjoy going out in the community and hanging the door hangers. And every now and then, somebody is outside already, so we can have a little conversation. And I think all of that is great, because at the end of the day, what I want to do is I want the community support, because I can't do it by myself. I'm going to need the community behind me, but I know with that community support behind me, the sky is the limit for the change that we can make in this city.
Okay. Keeping it clean, why are you more qualified than your opponents?
Keep it clean. So
keep it clean.
Look, one thing about me is I'm a professional, and I'm going to always conduct myself professionally. I think that judges, they obviously have to be competent, they have to be experienced, but they also have to have a certain temperament. And I think I have all of those experience out, in addition to the community service aspect that I have and the experience. None of my opponents have both of those things combined, and I have them both. You know, I've been a lawyer for almost a decade now, exclusively in criminal law. I've tried cases from, you know, your simple possession of drugs all the way to, you know, your murders and your rapes. I've tried those cases. I've tried a case in every section of court. So the experience is there. And then I have the community service aspect where you can see from my track record that I'm not just talking the talk, like I do it. I'm in the community. I was a teacher. I was a coach. I'm still a mentor. And all of those things are important to me. And I think the combination of those things make me the most qualified candidate in this particular race. You know, I'm running against two other individuals. Stephanie Bridges, I met her maybe once or twice in person, and we've done quite a few forums together. And what I can tell you about is I think she's a really nice lady. I think she and her campaign team, they obviously have a plan, and they're running their platform and they're running their plan. And it's been a positive one. And I can appreciate that because I'm doing the same thing. We're running a positive campaign. My other opponent, Gary Wainwright, you know, in some forms, he wants to kind of get some sound bites and jump at Miss Bridges and myself for that matter. And I think that just goes to show the type of temperament that he has, and also the temperament that a judge should have, which is not the one that he has, you know. So it's not surprising when you look into, you know, Mr. Wainwright's history that you see that, you know, his license has been suspended. He has some contempts on his record. Like, it's because of that outspokenness and basically that unprofessionalism that he has. And I don't think that's the type of temperament that people should look for a candidate on the bench. You know, I'm always going to be cool, calm, and collective. I don't really get too high or too low. And I think that's a positive thing here because, you know, in court, you sometimes you hear some real gruesome facts,
Right.
but you can't form your opinion on that. You know, you have to just hear it all out. And I think being even keeled, having being a consummate professional, and having that necessary temperament, I think that bodes well for me. And that's why I think I am the best qualified candidate for this particular race.
Okay. And is there anything else you want to add in closing that you think voters should consider before the election?
Just I just want to add this. You know, as a young kid, you know, I grew up, you know, in Gentilly, and I've always wanted to serve this community. You know, my family has been serving this community for a really long time, from my grandfather to my uncles, my dad, my brothers, several cousins who are still serving this city. And it's my turn, it's my time to kind of get on that bandwagon of that family tradition of serving New Orleans. And I want to do it from the bench. And I always leave everybody I talk to with what I call the 3 C's, JP. Chance, choice, and change. Give me the chance. Make me your choice. And together, watch us make change.
Okay. That's a powerful way. And do you have any Twitter, Facebook you want to put out there real quick?
So everything is DeLarge for Judge. That is on Twitter, on Instagram, on Facebook. If not, it's just Marcus DeLarge. The website is up and running. DeLarge for Judge, FORJUDGE.com. So I encourage everyone to go visit the website, check out my platform, take a look at who I am, what I've done. And I think after you view all of that, I think you'll see that there's only one clear choice for Section K, and that's Marcus DeLarge, number 94 on your ballot.
Okay. Thank you, Marcus. I appreciate your time today. It's been really illuminating.
Thank you very much.